because there is no ruling that I need to make, but I do need to indicate what is to happen as far as the Commission is concerned in the light of these latest developments involving Mr. Jacob Zuma. In terms of a summons that was issued by the Secretary of the Commission, Mr. Zuma was supposed to appear before the Commission from today up to Friday to give evidence and to be questioned on various matters which have been investigated and are still being investigated by the Commission, some of which were indicated by Mr. Pretorius in his address to me this morning. Because Mr. Zuma had previously walked out of the Commission or fled the Commission when he was supposed to take the witness stand on the 19th of November 2020, even though he knew that he had been served with a summons to appear before the Commission and to give evidence and be questioned and to remain in attendance until excused by the chairperson. He had walked out without permission and had not offered any explanation for his conduct to the Commission. The Commission feared that he would not comply with any further summons that could be issued against him by the Commission, and for that reason, the Commission launched an application to the Constitutional Court, in the Constitutional Court, for various orders, but mainly for orders that would compel Mr. Zuma to comply with the summons issued by the Commission and appear before the Commission and answer questions that would be put to him, and to remain in attendance and not leave without permission, without the permission of the chairperson of the Commission. When the Commission launched its application, it served Mr. Zuma with a copy of the papers, and he was informed in those papers that if he wanted to oppose the application, in other words, if he didn't want the Constitutional Court to grant the orders that the Commission was asking for, he should indicate his intention to oppose and file in the Constitutional Court affidavits where he would set out his case and state why the Constitutional Court should not make an order compelling him to appear before the Commission. In the affidavit of the Secretary of the Commission, one of the points that was made quite clear, which Mr. Zuma and his lawyers would have seen, is that it was going to be argued before the Constitutional Court that the fact that Mr. Zuma was going to be pursuing a review application in the High Court to have my decision not to recuse myself reviewed and set aside by the High Court would not in law be a ground to justify him not appearing before the Commission or not complying with the summons. That issue was placed in the papers. Mr. Zuma and his lawyers would have seen that, and it was up to Mr. Zuma and his lawyers, if they thought that that was not correct in law or that that was wrong, to have participated in the proceedings in the Constitutional Court and to have placed their argument that the fact that he was still going to pursue a review application was a ground for him not to comply with the summons and not to appear before the Commission. They knew that that point was to be argued. They knew exactly what the Commission would argue. They chose not to contest that in the Constitutional Court. They chose not to participate in those proceedings. One of the points also that was made in the founding affidavit deposed to by the Secretary of the Commission in that application to the Constitutional Court was the point that no witness before this Commission, including Mr. Zuma, has a right to remain silent once they take the witness stand. The Commission raised this issue because when Mr. Zuma's counsel presented his argument in support of the recusal application on the 16th of November 2020, his counsel at some stage said that he could put Mr. Zuma on the witness stand and ask him to say nothing. So the Commission realized that there seemed to be a view on the part of Mr. Zuma's lawyers that a witness before this Commission has a right to remain silent after taking the witness stand. So the Commission raised this issue in the papers before the Constitutional Court and made it clear that it was going to argue that there is no such right in proceedings before the Commission, and that such a right belongs to an accused person in criminal proceedings, not in this Commission. So when Mr. Zuma and his lawyers were served with the papers that the Commission had launched in the Constitutional Court, they knew that this is part of what the Commission would argue before the Constitutional Court. What the Commission said was that the only part which they could indicate is that the privilege against self-incrimination is available in appropriate circumstances to a witness who appears before the Commission. And that as far as Mr. Zuma is concerned, that privilege would apply to him as well, but not the right to remain silent. When, therefore, Mr. Zuma and his lawyers decided that they were not going to oppose the Commission's application to the Constitutional Court and that Mr. Zuma was not going to participate in those proceedings, they knew that this was one of the issues that were going to be raised. And if they believed that they had a case to the contrary, it was up to them to place their arguments before the Constitutional Court to enable the Constitutional Court to find in their favor if they were able to persuade the Constitutional Court. They chose not to do so either. Mr. Zuma had a full opportunity to put whatever reasons he believed, to put before the Constitutional Court whatever reasons he believed justified him in not complying with the summons or in not appearing before the Commission, and allow the Constitutional Court to decide whether those reasons were sound or not. He chose not to do any of that. He was free to also say to the Constitutional Court you can't compel me to appear before this chairperson of this commission because of the following reasons. If he thought that his reasons were sound and would be regarded as acceptable by the Constitutional Court. It is not clear why, if he thought he had good reasons, why he should not be compelled to appear before the Commission, why he chose not to put those reasons before the Commission, before the Constitutional Court. The Constitutional Court handed down its judgment and made an order that he should appear before the Commission. It made it clear that he has no right to remain silent once he takes the witness stand. In doing so, the Constitutional Court did not take away any right that Mr. Zuma may have had, because even before the judgment of the Constitutional Court, he did not have the right to remain silent in these proceedings. Actually, those who follow the proceedings of the Commission closely may remember that early in November, I think on the 6th of November, on the occasion when Mr. Dumieni appeared before the Commission, the evidence leader, Ms. Kate Hofmeyer, addressed the question of the right to remain silent and the issue of the privilege against self-incrimination. In that address, which can be accessed by anybody who would like to access it in the transcript, she made it clear that as far as the evidence leaders are concerned, there is no right to remain silent. There was only the privilege against self-incrimination, and indeed, she referred to cases, to case law that deals with the issue of privilege against self-incrimination by our courts. And in this regard, she referred to a judgment of the Appellate Division in Mahmoud, or Mahmoud versus Janse van Rensburg and others, 1993, Volume 1, SA 777A for Appellate Division, which dealt with that issue. In that case, too, as long ago as that time, the Appellate Division had made it clear that the privilege against the refusal to give evidence on the strength of the privilege against self-incrimination is not there for the taking, and that there must be reasonable grounds for an apprehension that the witness may incriminate himself or herself. That the Constitutional Court also said. So it is not something that really had not been there before. There might be one or two aspects that were emphasized or added by the Constitutional Court, but that there must be reasonable grounds before the privilege can be invoked had been dealt with by our courts before. In fact, either on the last day when Ms. Mienyo gave evidence or towards the end of her evidence, I specifically dealt or requested the legal team, and it's in the transcript, that they should carefully go through Ms. Mienyo's evidence to see whether all the questions that she refused to answer on the basis of the privilege, whether there were reasonable grounds for that. So, in effect, I did not make a ruling, any final ruling that she had correctly invoked it. I allowed that the legal team should go through the transcript carefully, and then where they believe that there are no reasonable grounds, she can be called back and she can that issue can be dealt with. Ms. Mieni has not dealt with certain issues relating to ESCOM, and she is supposed to come back, and when she comes back, she can, once the legal team has carefully gone through her evidence and all the questions she refused to answer, she can be asked questions about the existence or non-existence of reasonable grounds for her apprehension that she would incriminate herself if she answered certain questions. So I repeat my request to the legal team to please go through that evidence and come to take a view so that it can be dealt with properly. So with regard to Mr. Zuma, the law would be the same that would apply to his evidence. The Constitutional Court has not taken away any rights of his as far as the privilege against self-incrimination is concerned. It is a pity that Mr. Zuma has decided not to appear before the Commission today in defiance of the summons issued by the Commission and in defiance of the order of the Constitutional Court, our highest court in the land. It would be a pity if anybody did it, but that this was done by a former president of the Republic, someone who twice stood before the nation and took an oath that he would uphold the Constitution of the Republic and protect it. Is a great pity. The Commission did not just rush to issuing summonses against Mr. Zuma to compel him to appear before it. The Commission did not just rush to the Constitutional Court to get an order to compel Mr. Zuma to appear before it. The Commission did so when it was clear that he really was not prepared to comply with the summons. The Constitutional Court has made it clear in its judgment that a witness who has been summoned to appear before the Commission is not supposed just to come to be present here. He or she must come to testify and answer questions, and that he or she may not leave before the proceedings are completed or before he or she is excused by the chairperson. On the 19th of November, Mr. Zuma left the proceedings of the Commission before they were completed and without permission from the chairperson, even though a few minutes before he left, he had been reminded by Mr. Pretorius that it was not up to him to just up and go. An order of any court is binding on those to whom it applies. A summons is also binding on the person to whom it is directed. And if a person has been issued with a summons, has been served with a summons to appear in court or in any forum or tribunal, and he or she thinks that the summons should not have been issued or the summons is irregular, it is not up to that person to just ignore the summons or to defy it. His or her obligation is to approach the courts and tell the courts why he or she says the summons should not have been issued, or why he says the summons is irregular and should be set aside. And only if he or she succeeds in getting the court to set the summons aside is he or she entitled not to appear. But as long as the summons has not been set aside, it is valid and binding on the person, and he or she must comply with the summons. That principle was stated by the Constitutional Court in the context of the Public Protector's remedial action in the Nkandla matter, and Mr. Zuma should know that principle. In this case, he has decided to ignore the summonses issued by the Commission and not to go to court to have them set aside if he thought they were invalid or they were irregular, but to just ignore them as if they do not exist. First, he walked out of the Commission proceedings on the 19th of November. Second, despite having been served with a summons to appear before the Commission in the week beginning on the 18th of January 2021, he decided not to appear, even after he had been reminded by the Commission that the fact that the judgment of the Constitutional Court had not been given did not mean that the summons had been suspended or set aside, and that he should appear. He decided not to appear. He has done the same thing again. This is very serious, because if it is allowed to prevail, there will be lawlessness and chaos in the courts, because there may be other people who will decide to follow his example when they are served with summonses and other court processes and decide that they can ignore them. Summonses and subpoenas get issued in our courts every day throughout the breadth and length of the country, in the magistrates' courts, in the high courts, and in other tribunals. And if the message that is sent out is that people can ignore or disregard or defy summonses and orders of courts that get issued by various courts every day in our country, and that they can defy those with impunity, there will be very little that will be left of our democracy. Our Constitution tells us that we are all equal before the law. We are all subject to the Constitution and the law. And we are all required to obey orders of courts. And if we are not happy, we are not supposed to just sit back. We should take steps to approach appropriate courts to appeal or to have those orders reviewed. And when it is the highest court of the land, That is the highest court of the land. And you are bound, whether you like the order or not, you are bound by it and you must comply. There should be no two legal systems in regard to these matters. There should be no rules for some and other rules for others. We should all be subject to the same laws. Whether I am the Deputy Chief Justice of the country, or I am the Chief Justice of the country, I'm the President of the country, I'm a former President of the country, we should all be subject to the same rules. That is the Constitution and all our laws. There are witnesses who are supposed to appear before the Commission next week and in the weeks after that. Some may be wondering what will happen because they too may have been issued with summonses by this Commission. There are more than 250 witnesses who have appeared before me over the past 3 years. Many of them have appeared without being compelled. Some have been compelled and they subjected themselves to the law and appeared. None of those more than 250-something witnesses has asked me to recuse myself. Only Mr. Zuma has done so. I've just completed 24 years of service on the bench as a judge. And many litigants have come and gone and have appeared before me, literally thousands in trials, motion court, in appeals, and only Mr. Zuma, out of all of these, has ever asked me to recuse myself. But it is fine because he's entitled to raise whatever issues or concerns he has, but then they must be dealt with within the legal system. And if he's not happy with my decision, he is free to take the next steps in terms of review. But as we understand the position, he is not entitled, because of that, to refuse to appear before the Commission and to refuse to comply with a summons and to refuse to comply with an order of our highest court. Given all of these circumstances, as I said earlier on before lunch, I have to indicate what the Commission will do, and our law is clear. There is no lacuna in our law on this matter. The Commission views Mr. Zuma's conduct in a very serious light, particularly because it's repeated conduct. The Commission has not treated Mr. Zuma unfairly at all. He has no valid or sound reason for not appearing before the Commission. The Commission has taken note that in this type of situation, the law makes provision that it may apply for what is called, it may institute what is called contempt of court proceedings. The Commission will do so. What that entails is that the Commission will make an application to the Constitutional Court, which is the court that made the order that Mr. Zuma has defied, and seek an order that Mr. Zuma is guilty of contempt of court, and if the Constitutional Court reaches that conclusion, then it is in its discretion what to do. One of the things it can do is to impose a term of imprisonment on Mr. Zuma. Another would be for it to impose a fine. The Commission will approach the Constitutional Court and ask it to impose a term of imprisonment on Mr. Zuma if it finds that he is guilty of contempt of court. It will be up to the court what it considers appropriate, but that is what the Commission's position is. Mr. Zuma will be given a full opportunity to oppose that application if he wishes to, and place before the Constitutional Court whatever facts and arguments he wishes to place before it, and the Constitutional Court will decide. And that is all I wanted to say. I think it's clear what the Commission will do.
Noted. Thank you, Chair.
We are going to adjourn the proceedings. There will be no proceedings tomorrow. If the Commission is able to make arrangements to bring some witnesses and make use of some of the days this week, it will announce. But this whole week had been set aside for the hearing of Mr. Zuma's evidence. And he's not here. He won't be here for the rest of the week. We adjourn.
So that was Raymond Zondo, the chair of the State Capture Commission there, just telling the public that he and the Commission have decided to go to the Constitutional Court to apply for what they call a breach of, for a contempt of court order against former President Jacob Zuma, because he did not attend the Commission as he was supposed to. Yet again, this time is the second time he has decided not to do this. And they say that they're going to be opting for him to be imprisoned if indeed the Constitutional Court finds that indeed he was not compliant with their order and the State Capture Inquiry Commission's summons for him to attend between the dates of the 15th and the 19th of February. So that's the decision that they've taken, and so we proceed. The